Today we're examining a controversial legal case at the US Naval Academy. Two former Navy football players, Joshua Tate and Eric Graham, face serious charges related to an alleged sexual assault. To help us break down the complexities, I'm joined by legal expert Dr. Alexis Monroe. Dr. Monroe, can you briefly outline what's at stake here?
Absolutely. This case involves allegations of aggravated sexual assault and abusive sexual contact, both falling under the Uniform Code of Military Justice. The stakes are high not just for the accused, but for the military's approach to sexual misconduct, public trust, and the accuser's well-being.
Given the military context, does the legal process differ from civilian courts?
Yes, significantly. These cases proceed under military law, involving Article 32 hearings, court-martial proceedings, and unique evidentiary standards. The chain of command and military culture also play crucial roles, setting this process apart from civilian systems.
Let's build on that. What exactly is an Article 32 hearing, and why is it so pivotal in military justice?
An Article 32 hearing serves as a preliminary investigation, similar to a grand jury in civilian courts. It's designed to assess whether enough evidence exists to warrant a court-martial. These hearings are thorough, often involving days of testimony and extensive document review.
In this case, over 20 witnesses and hundreds of pages of evidence were considered. Is that typical?
It's not unusual in high-profile or complex cases. The volume reflects the gravity of the charges and the need for a comprehensive evaluation before moving forward with prosecution.
Interestingly, the investigating officer recommended against taking the case to court-martial. What factors led to this advice, and how common is it for such recommendations to be overruled?
The officers cited heavy damage to the accuser's credibility, which they felt eroded the reliability of her testimony. While recommendations are influential, commanding officers can and sometimes do override them, often due to public scrutiny or perceived institutional obligations.
So, would you say this reflects on the military's handling of sexual assault allegations overall?
Definitely. There's ongoing debate about whether the military prioritizes justice or reputation. Sometimes, proceeding with prosecution, even against recommendations, is seen as a statement on zero tolerance.
Let's transition to the role of command. Vice Admiral Mike Miller ordered the court-martial despite the recommendation. Why does command have this authority, and what are the implications?
Commanders are entrusted with prosecutorial discretion under the Uniform Code of Military Justice. The rationale is to maintain good order and discipline. However, critics argue this centralizes power and risks decisions being swayed by external pressures rather than pure legal merit.
Are there any safeguards to prevent misuse of this authority?
There are review mechanisms, but many advocate for independent prosecutors, pointing to cases like this as evidence that change may be necessary.
A major element here is the accuser's memory gaps and credibility. She admitted to heavy drinking and limited recollection. How does trauma and intoxication affect memory in such cases?
Trauma can fragment memory, often causing victims to recall events inconsistently. Alcohol complicates this further by impairing memory formation, which defense teams may exploit to challenge credibility. However, neuroscience shows trauma-related amnesia is a well-documented phenomenon.
Does this mean victims are at a disadvantage in court?
Unfortunately, yes. Juries and judges often expect detailed, linear recollections, but real trauma rarely works that way. This mismatch can undermine otherwise legitimate claims.
The defense scrutinized the accuser's sexual history and personal life, raising concerns about victim blaming. Are such tactics common, and what impact do they have on survivors?
Regrettably, these strategies are widespread. Defense attorneys may delve deeply to cast doubt or embarrass. This can re-traumatize victims and discourage reporting. Studies indicate only a fraction of military sexual assaults are reported, partly due to fear of such treatment.
Are there legal protections to shield victims from these invasive lines of questioning?
There are so-called rape shield laws, but military courts sometimes interpret them narrowly. Advocates push for stronger safeguards to prevent unnecessary victim humiliation.
Given the media attention and institutional responses, how does public scrutiny affect military sexual assault prosecutions?
Public scrutiny can pressure the military to act decisively, sometimes erring on the side of prosecution. However, it can also complicate proceedings if decision-makers are more concerned with optics than justice. The balance between transparency and due process is delicate.
Have high-profile cases like this led to any tangible reforms?
Yes, there's been movement towards independent prosecution and enhanced victim support, but many argue progress is slow and uneven.
Despite proceeding to court-martial, the investigating officer predicted low chances of conviction. Why are military sexual assault cases so hard to prosecute successfully?
Multiple factors contribute: lack of physical evidence, ambiguous memories, and the close-knit nature of military communities. Conviction rates remain low. In Pentagon report found only 7% of cases from 2022 led to conviction, compared to about 18% in civilian courts.
Does this suggest systemic issues within military justice?
It does. Critics cite insufficient training, bias, and the unique pressures of military life as barriers to justice. Calls for reform grow louder with each difficult case.
Let's compare. How does the handling of sexual assault differ between military and civilian systems?
Civilian courts use independent prosecutors and juries selected from the general population. In contrast, military courts rely on officers who may know the accused or accuser. This can introduce bias, intentional or not. Additionally, military culture values unit cohesion, which can discourage reporting.
Is there a model system anywhere that the U.S. military could look to for inspiration?
Some countries, like Canada, have moved toward more civilian oversight for military crimes. Hybrid systems could help, but adapting them to the U.S. context presents challenges.
As we wrap up, what reforms could most improve justice for both victims and the accused in military sexual assault cases?
Key reforms include establishing independent military prosecutors, enhancing victim protections, and providing comprehensive training on trauma-informed interviewing. Increased transparency and data collection would also help ensuring both accountability and fairness.
If these changes are implemented, do you foresee a significant shift in outcomes?
While no system is perfect, evidence from other sectors shows that independent prosecution and strong victim advocacy correlate with higher reporting rates and more just outcomes. It's a step towards restoring confidence in military justice.